Hi, I'm gonna discuss about the reflection and lessons part. Okay, regarding the section 1F of the Criminal Evidence Act 1898 in UK and section 54 subsection 2 of Evidence Act 1950 in Malaysia. I learned that section 1F of Criminal Evidence Act in UK, which is used in this case, is the same as section 54 subsection 2 of the Evidence Act in Malaysia. Both sections mention that a person shall not be asked and not to answer the same on any question to show that the person has been charged, committed or been convicted of other offence than what is currently charged with, which causes him to be charged or be viewed as a person of bad character, unless if there is a proof that prosecution can establish a good character or establish a bad character in the court during the proceedings. This provision is indeed breached by the prosecution in this case during the cross-examination, and also the defendant counsel by not objecting to the question earlier on. Thus, the question should not have been admitted as evidence by prosecution counsel, since none of the three exceptions were satisfied, and that was unfair to the appellant. However, despite the breach in this case, there was no miscarriage of justice, which led to the fair proceedings when the judge delivered his verdict throughout all three courts, in which the appellant is held guilty even without the admission of the questions during the cross-examination. There are several cases that explains what the discussion above. In the case of Maxwell versus Director of Public Prosecution, this is the case used by both appellant and the judge to argue their points. However, there are different understanding on this case, which led to the Lords to consider on carefully and decided that the learned judge has erred in this verdict. In this case, it is stated that where the prosecution had not enough evidence to convict an accused, there should be no any questions about the occasions in later trial at which the accused puts his character in issues. In other words, if there was no previous case in which accused was acquitted or committed, it cannot be used on the accused in the present case. I found this principle to be wise and considerate, as the accused rights are considered as well in making judgment. In the case of Rex versus Vatam, the same principle had been used by the judge to explain about the character evidence, that he delivered the verdict by the way of, indeed, character is not restricted to mere reputation but also disposition. Perhaps disposition of a person cannot be seen, thus one may not know of the person's possible inner bad characters. As a conclusion for the reflection, in my opinion, the case is used by accused person to get some mercy when the state does when he state he have a good character, but there's a contention when the prosecution question the accused in other way to raise a suspicion and different view of the accused person's good character. However, in this case, the appellant could not use this case well, since he was guilty even with the cross-examination question being admitted. Character evidence plays a substantial and important role for the accused person whom been charged for the first time, since they can establish good character and as evidence and tender in court, and to raise doubt as a defense against a prima facie evidence admitted by the prosecution counsel. However, it must be assist by the prosecution counsel in raising suspicion to the defense of good character of an accused person, because by establishing that the accused person is of a bad character with adequate evidence to be tendered in court, the defense of good character immediately becomes useless, and the case then falls in favor of the prosecution counsels. Okay, now we look for the part of recommendations or suggestions. Okay, as a suggestions based on this case, the position and adoption of this law and the principles in Malaysia, or either in English cases, are not uniform, or to be said there is no standardized on the application of the laws of these principles and laws on bad character evidence. The approach in most of the cases are pertaining to the person's characters, and there might be unfair or miscarriage of justice when delivering the judgment. The court must look upon the wastage of the accused evidence in relation with the character evidence. Thus, the current provisions on the character evidence in Malaysia had to be amended, in my opinion, to be more specific when it comes to the issue pertaining to the character evidence. Moreover, there could be infusion of the hearsay element or evidence about the reputations of one's character. It may be based on the rumor, and there could be a prejudice to against the accused Thus, the court may look upon for the application of character as fact in issues. As fact in issues in this part, we can say that the prosecution must play their roles to convict or prove the accused that he have a bad character, and they can, by this way, by virtue of this bad character evidence, they can the judge can consider whether there is a real contention on the character evidence that been tendered, and can sentence or can punish the accused based on the character evidence that been tendered to the court. So as a conclusion, in my opinion, in Malaysia, the approach of bad character evidence is still in the level of improvement. So the court, the judiciary bodies must have an initiative on uphold this principle and laws for the future cases. With that, I end my discussions today for this case review. Thank you.